हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है. आई एम सॉरी दिस इज ऑल्सो क्रूशियल टू दिस. मैं पेज 18 पे हूँ सर, पैरा 16. It's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Paragraph 16. Surprisingly, this question, page 18, surprisingly this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between Parliament or state legislature and the courts. Non-interference with the view of the majority in Parliament with regard to what is reasonable and interference with what is prohibited by the Constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran 2015 SCMR 1739, this court, while stating the rules which must be applied to declared laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions. So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
Sir, I try to read everything which your lordships write, whether reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if, for the purposes of legislative competence, appeal is a part of procedural law, if that is so, then Parliament can also confer appeal.
Not all appeals, but intra-quota.
Intra-quota. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184(3) are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous power exercise.
This Order 5 Rule 2 that you read, even though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the parties, and the rules are providing for that appeal.
Yes. So this is one way I can add that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes.
Okay.
Yes. And why they are not always restrictive, my lord.
If I may follow what my learned colleague has said with regard to Order 5, why didn't
I can't hear you. I can't hear you. Sir, I can't hear you.
So sorry. What my learned colleague said regarding Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So this is a review?
This is not a review. This is a reconsideration.
Sir, it is like a review then.
No, it's not.
A review, practice and procedure में review का power confer कर दिया.
ये देखिए ना जी. अगर deliberately
in an appeal, can't judge who passed an order sit?
Sir, that is not the notion of how.
I suppose he's one judge. I don't know. For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is because one set of arguments were, the third judge hasn't heard the arguments as were asked, or that particular question as articulated was not put to them.
Yes, yes.
So that can the Chief Justice then say, can you all three sit together and decide it, since now the possibility of a hung court will not arise. It can still go in three different ways. So what is that called? I mean, that option is available to the Chief Justice. I'm adding another member on the bench and hear this matter again, or whatever you want to call it.
And if I could add to that, if you look at Section 5, you see, I mean, this is a traditional notion, but if you look at Section 5 of the law, the one under challenge,
yes,
it says that the appeal will go to a larger bench. Now, I just, want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? I mean, traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't one or two other judges be added to it? I mean, is there a problem somewhere, or does it?
My Lord,
is there
for instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and one judge has been removed, 3 have been added. So that judge here, himself being bench, is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as His Lordship, Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your Lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal. You kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this
There
word
are
reconsideration.
two parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is against
the order of the registrar in
but
chamber.
that is
And
against
suppose if we
registrar.
were to consider Section 5
That
and
is why
consider it
the
as a
word-
reconsideration,
That is why the word reconsideration has been used, in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it is not just like an appeal.
But let us
See,
and if we were to just say that Section 5 is a reconsideration, and
Sir,
let's
may I-
not in the word appeal,
let's
could it
just
not
focus
then
on
pass
this
the
word
muster?
reconsideration. What is happening? Sir, मैं एक बात
that is why
मैं एक बात
it is not an appeal, reconsideration.
लेकिन ये आप देखिए, ये जो review